Yes, please, Your Lordship. Your Lordship, I'd like to mention one IA for listing, Your Lordship, IA civil for listing, Your Lordship.
IAS
First step-
civil,
Yes, Your Lordship.
what is the matter?
Your Lordship, it's matter relating to pensionary benefits, Your Lordship.
Hmm.
There is a stay already, Your Lordship. So I am for the respondent, private respondent,
Hmm.
for stay vacating, Your Lordship.
Next week.
Next week, payment for listing will matter also. The next week immediate also.
Very to the Lordship. I beg to mention three matters for admission hearing, Lordship, listening for. Lordship, those are relating to recruitment in SSC, Lordship, CIPF, the constable post, Lordship. So, matter was fixed after police, but police has been left, but it is not listed. So
No,
maybe.
but why don't you find out from the register why it has not been listed? Find out and come. If it is not listed for no reason, then we'll give a mention. Inquire and find out. Yes.
Lordship, beg to mention to listing on the item for motion tomorrow, Lordship.
What is the urgency?
Lordship, our Lordship, our provident fund has been withheld, Lordship.
Monday,
Lordship,
Monday. Yes.
Lordship, I file in 28 to
Monday. This matter can wait till Monday. Yes.
May I please, Lordship, I am praying for the listing the matter. It is a writ petition and kindly fix the date for the admission. After 2 weeks, it is the matter of termination of salary of the petition and we are for the.
Termination of salary. There is nothing called termination of salary. What is your matter?
Termination of salaries of petition.
Termination of,
Salary of petitioner.
there is nothing called termination of salary. Is it termination of service?
So not.
You
Salary.
find out and come back. You make a mention at 2, you make a mention. Find out what is the matter about. You should know what is your case if you're mentioning, is it not? Find out and come back. Yes.
Hey, please, my lord, I beg to mention a matter for admission hearing, my lord. Matter was last listed in on the last
Ask the registry why they have not listed. After that you come back.
My lord.
Let the registry also do some work, is it not? All right.
Of that.
Daily list for motion item 1.
And from board, they are working since 1999,
Hmm.
and from 2002 and 2008, they have been working as workers. Now the board, they are under Assam Urban Water Supply Sewerage Board. Now they are seeking to transfer them to the local authorities and local municipal board. That will create problem in the sense they are not getting salaries and they will not be getting salaries if they are transferred to the board. So therefore, the municipal, the managing director of the board has written a letter to the government that this kind of problems are there. That your lordship will find it at page 112. This is the letter to the by the managing director of the sewerage board to the deputy secretary to the so these are the problems.
So they are working as master role workers.
They are working as now workers accepting 3 employees, 3 petitioners. Others are working as master workers employees.
So they are drawing a pay scale.
They are drawing scale, yes, accepting 3 petitioners.
Hmm.
Accepting 3 petitioners.
So how you have joined in the 3 with the others?
No, but accepting, my lord, they are not saying.
How you can join?
No, we are same cause of action in a sense. My lord, everybody is would be transferred to the local authority.
That's correct.
Yes.
Those who are drawing a pay scale,
Yes.
we can say that the government will ensure that they get the salary as per the pay
But
scale.
master role worker also.
How can we say that for the master role workers?
If your lordship wants, I can separate it.
No.
But
Court doesn't want anything. All we want to know is how a common order can be passed to give relief for both the parties.
Only, my lord, only what I want is that, my lord, they should not be transferred to this department now, without sorting out the problem.
All right,
problem raised by the-
so that is the relief your clients are seeking.
Yes.
So whether that kind of a direction can be or need be given is a matter we'll examine. But supposing the court passes an order saying that wherever they are placed, their service conditions will not be altered. In that case, the service conditions are only applicable to those who are drawing pay scale, not to others. There is no condition of service
In
for others.
similar matter where pay, I think master role workers and worksite employees are there, the code directed status quo to maintain status quo. That your lordship will find 137.
Is there any answer to my queries? Please say that.
That difficulties I will face it, I know. it,
Uh-huh.
That difficulty is there, I should have taken up separately. These three petitioners, petitioner number 35 and 37.
What is the status quo? Where is the order? Let us
Page 137.
Page 137.
This is in respect of other districts.
Yes, that's the order, service conditions.
Yeah.
Transfer or no transfer, there is no status quo.
To maintain status quo. So far as this.
No, maintain status quo insofar as service conditions.
Of the petitioners are concerned.
Yes, as long as their conditions of service are protected,
This will be-
whether they are transferred here or transferred there, that doesn't matter.
this will-
So that is an order which cannot be granted in the writ petition. Because the master workers do not have any condition of service.
But master role worker, they are also working since 1999.
That's not the point. Point
Yes.
is, do they have a condition of service?
Condition of service is not there unless they are promoted to work. So that I accept. Accepting 35 and 37, you will also pass this.
Mr. Das, very difficult.
35 and 37, I'll delete their name, I'll get it come separate.
See, these kind of things are creating big problem.
That's
And
the-
the problems are getting to be attributed to the court. Although the courts are not responsible for this. What to do?
35 and 37, your lordship may, I'll take and I'll strike off their name.
You probably did not even know that.
Lordship.
You are probably not even aware of this dichotomy, is it?
Lordship, actually what happens, Lordship, on 14/3/22, all the staff were being handed over to the local Silchar Municipal Board. This is the handing over letter, Lordship. Now they have come before this honorable court, but
So then was this order of status quo passed without
no,
hearing?
no, that for other district, not for Silchar, Lordship. This is for Kachar district. This one is already been handed over in the year 2022 only.
No.
Already. For-
No, no, no.
Already 22 days.
No, working.
কিন্তু এটা municipal board আছে, আমারটা কম।
Page 11, later.
এখানে আমার জন্য বিষয়, এখন দিন হচ্ছে,
This is dated March 30. Came to proceed. Person given.
So, Mr. Das, have you seen this
No, I
letter?
haven't seen.
Just have a look at this.
যদি আপনার কোনো man
Are your clients covered under this letter?
They are saying but 14/3/22 and at the same time page 112, that is dated 28/3/22. Man has not been, all the persons have not been transferred now. To the municipal board, they have not, because municipal board, they themselves have written, annexure, 9,
No, Mr. Das, please,
Yes.
please appreciate one thing. This is a decision of the government
government, yes.
to transfer the assets, liabilities, man, material of the Assam Urban Water Supply Board
Yes.
to the Silchar Municipal Corporation Board. So you cannot have any objection to that, provided the conditions of service of the petitioners is not affected in any manner.
Yes,
Correct?
this is what. it is.
So is there any allegation that pursuant to this transfer, the condition of service of the petitioners would be or has been affected adversely in a particular manner?
They will not be getting salaries because Silchar Municipality Board's employees are not getting salary. Let them take instructions on the matter, my lord. They are not getting salaries and from here, my lord, from June 22 to January 21, June 21 to January 22, no salaries have been paid. And again from
But that
November
was the time your clients were in the under
About.
board.
board, and from the November 22, there is no salary. So therefore, this issue has to be sorted out. If I am transferred to any other department, I have no problem. But the municipal itself is facing problem. I have annexed my lot, annexure 9, 10.
No, but in the synopsis, it's written that they were transferred without the consent of the petitioner. Are you pressing that point? No.
No, I'm not going there.
You're not going
Let them protect my interest, because your lordship will kindly see, Malat, Lanka municipal.
Yes,
board
Mr.
has
Das,
written-
is it a engineer's way of getting rid of some employees that you go to municipal board and don't get any salary?
No, this is the decision of the government, Lordship. This is the decision which was taken by the Urban Development Board, Lordship.
Hmm.
And since Assam Urban Water Supply is under Urban Development Board, so they are bound to comply.
So
And this is
the
the
Silchar municipal board has to be implemented as a party then,
Lordship.
They're
a party.
No.
executive engineer, director municipal board is there, executive engineer, Silchar municipal board is there. Respondent number 9.
Hmm. So we'll issue notice at this stage. What else can be done?
Malat, what interim as regard payment of salaries, my lord, your lordship will fix a date, because from June 21 to January 22, they are not getting salaries. And from November 22 onwards, no salaries at all. Who is going to pay? If you are transferring the persons from the board to municipality, some sort of arrangement has to be made from where they are going to get salaries. The scheme has been transferred, persons have been transferred. Tomorrow, if I am regularized, my lord, how my seniority will be protected?
That's correct. There you have a point.
So therefore, my lord, all this matter, they will have to sort it out, then transfer it. There is no problem, my lord, since there is difficulties on the part of the board. So therefore, my lord, if they are transferred to the municipality board, they themselves do not have any resource. Lanka Municipality Board, Golaghat Municipality Board, Dergaon Municipality Board, they have written letters to the government, my lord, saying that we ourselves do not have any fund.
Hmm.
That one page, your lordship can see 118. This is from Lanka Municipality Board.
Mr. Das, I wanted to pose a question to you.
My lord.
Payment of pay scale, other allowances, etc., for which we may have to ask current government advocate Assam are present on behalf of the state. On behalf of the official respondents and do not have any objection if the prayer is adopted. Mr. Das, we want to settle these matters once and for all.
My lord,
So kindly,
I'll do.
your juniors may
May I
not
take
be,
this copy, my lord?
your juniors may not be so conversant with the
I'll
requirement.
have to put on.
You have to, you have to guide them a little
Right.
and maybe settle the draft.
Yep.
Because these
Otherwise,
difficulties are
it-
creating a lot of problems,
Lot of
unnecessary problem. Number of contempt cases piling up. You will be shocked if you see the number.
I think there.
So this hurry of getting an order from the
No, no,
court
I'm
is
not,
not helping anyone.
because the matter has to be sorted.
Ultimately, the government is at a loss to go forward or go
Government
back.
has passed an order, my lord, saying that it will be transferred. The municipality itself is burdened. They are not paying say, the salaries to their employees.
That's right. So you have relied on an order,
Yes.
status quo and service
Yeah,
condition.
I,
But then what is the way to implement it in the light of
I'll
this?
do it.
All right.
Declare.
So there is an order on person 2/1/2023.
Yes.
Now,
So
in terms of that order, look here. Excited, your lordship.
25 FF.
25 FF Lordship,
No, what is the petitioners are all employees or widows of the employees of, what is it, Politex?
Assam Politics, that is a government company.
So.
That company,
Please, please.
that company is not functioning since 1994.
Hmm.
There was an attempt for its revival by introducing a private entrepreneur. And then an agreement in this regard was signed.
Hmm.
Despite that agreement, it could not yield any result. Thereafter, in the year 2001, another agreement was made. By that agreement, the government wanted to transfer their 100% share to the private entrepreneur. And despite that agreement, nothing has been done. Nothing could be done. Now, as a result, Lord, these employees have not received anything whatsoever.
Anything means what?
Their retail benefits
Hmm.
or the retention benefits.
Hmm.
Now, after all, these persons are the employees of the government company.
Hmm.
And this government company is not functioning since 1994.
Hmm.
And an attempt was made in the year 2001 to revive it.
Hmm.
But that attempt failed.
Hmm.
Now, as a result, they have not, what is their stand now? They are not getting anything, you know. Now, at one
No,
point,
just a minute, just a minute. So since 1994, they are not getting anything,
they are not getting anything.
but the writ petition is filed in 2015.
No, 2001, in the year 2001, my lord, share was transferred to the private entrepreneur. Thereafter, in the year 2006, government adopted a policy to give VRS to those employees.
Hmm.
And we approached before this honorable court for grant of VRS.
Hmm.
This honorable court directed the government to consider our case.
Hmm.
And passed consider our case. We represented before the government. The government took a stand that as we have transferred our entire share to a private entrepreneur, the question of sanctioning any VRS does not arise at all. Being abridged by that order, we have come before your lordship.
No, obviously, how can there be a VRS in 2006 for a company which was shut down in 1994? No, Mr. Dasgupta, what I am asking is, I can appreciate your clients seeking some relief in terms of, pecuniary benefits. What I want to know is that what is the mechanism through which such a prayer can be considered at this point of time? What is their entitlement? Are they retrenched employees or is it that
So far, if
they lost their job because the company's operation has shut down?
if we go through the provisions of law, my lord, when when a company is transferred to another company,
Hmm.
then the employee concerned who are working in that establishments are entitled to have the retention benefit if the condition of service of the other company is not better.
Hmm.
That is one aspect. My lord.
So it was transferred to which company?
That was a government company. Assam Politics Limited was a government company.
Hmm.
The government could not operate it. They made an attempt to transfer it to the private company.
Hmm.
That private company has also not made any effort to revive it. As a,
No, was it transferred?
according to them, it was transferred because by virtue of a settlement, by virtue of an agreement.
Transferred to in favor of whom? Are they parties in this case?
No.
The government transferred it to which company?
To a private entrepreneur.
Private. But that is not an entity, that's not a party in this process.
But that is not, there is not a party in this. No, despite that transfer, nothing had happened.
So are they admitting that the company was transferred to a private entity? Government
Yes.
has admitted.
Yes, sir. They are
They
admitting
admitted.
this thing.
Yes, no, agreement was done, 100%
Agreement
share
was done.
share was transferred.
Agreement was done. 100% share was transferred.
Nothing.
So whether by that agreement, my condition of service will be affected or not. I am entitled.
But that company is not a party here.
But that company, so far that settlement is concerned, this settlement has not been implemented. No effort was made to revive this company. So we are not
No,
concerned
that is
with that.
correct. So are you sure that the other transferring company does not have any role to play here?
No,
We'll we'll record it then.
Yes,
But
yes.
if that becomes an issue, then the petition fails on that ground.
well,
That you are.
because that has not been revived. Company has not been revived.
Mhm.
It is as it is in the years, as it was in the year 1994. This is something a scam, my lord. If I am,
So that's the problem. Unless that entity is made a party and we are asked to ask them to explain what has happened, it will be very difficult for the court to take a view on that. Then you have to completely forgo that chapter of transfer.
yes, yes.
So there was no transfer of the company.
Actually, so far that settlement is concerned. By that settlement, an attempt was made to revive this company. But the company has not been revived.
Mr. Dasgupta, I am putting a very simple question to you. If your claim takes into account the fact that there was an attempt to transfer the shares of the company
By the government
by the government
to
to
a private
private entity, and that was also done
by their agreement,
by an,
by this.
there is a share transfer agreement?
Well, yes, there is a share transfer agreement.
Is there a share transfer agreement?
Share
This has
transfer-
received the approval of the ROC?
Lordship,
The share transfer agreement has received the approval of the ROC
that is not there.
under section 111 of
That-
the
that is-
Companies Act?
That is not there, Lordship. That part is not there on the record. But
Mr. Dasgupta, I think I know a little bit about the company procedure. Therefore, it will be
Yes, sir.
difficult for me to pass an order in this case unless the other party is other private entity is the party. Because these matters, there is a way of going forward, according to me. Without that aspect being considered, it will be very difficult to pass a mandamus. You will want a mandamus.
Hmm.
Difficult. I think you should try.
Oh,
it
no, no,
before.
I have waited.
What happens is the share trade, merely saying that there was an agreement is not enough.
Yes, yes, yes.
There is an elaborate mechanism laid down under the Companies Act. Depending on to what extent that mechanism has been invoked and completed, the court can only come to a conclusion whether this is a case where there has been a valid transfer, and if so, what would be the extent of liability, upon whom, and if there is no valid transfer, the consequences thereof. This is an important aspect which the court will have to deal with before issuing a mandamus. And
Well,
that
but-
aspect cannot be dealt with unless the transferring company is heard.
Lordship,
All right.
You see section
then-
111 of the
yes,
Companies
but,
Act.
Lordship, what has happened?
Give them Companies Act.
Section 111.
Lordship, what has happened is that
If I remember correctly, I
Uh,
dealt
uh,
with these matters
no.
15 years back. I hope my memory serves me
though
right.
there is nothing on the record here, Lordship,
Hmm,
I have checked the company website, ROC website. So shares have been transferred and these people have become the member of the directors of the board, the owners of the private entity.
Right.
So it looks like it's deemed that like this has been done as per the Companies Act.
Then they will have liabilities. The private owners will have liabilities.
Yes, obviously,
And
Lordship,
they are not even parties
they are
here.
not even a party. And another three things, Lordship.
We can direct attachment of their properties and put it in, but you have not even implemented them.
And another thing is that Lordship, there's retrenchment, the issue of retrenchment which they have raised now,
Hmm.
whether this retrenchment issue can be adjudicated before this honorable court.
No, it cannot be.
So there are disputed facts.
Either it will be an industrial
Justice
dispute
tribunal because the right.
or it will be a,
Yes, Lordship.
in that case also industrial dispute, another provision against the new owners of the company. That will depend on what are the terms and conditions of the agreement, whether the union has been consulted with. Each, you know it, each violation will have different consequences. Without going into all these things, so and so has come, so and so has come, so consider representation, give them benefit. These orders have never yielded any result. And therefore this court is reluctant to pass these orders. Either I'll pass an order after understanding all the facts and law, consulting everything. An order, if passed, must be implemented,
Yes.
subject to reversal and appeal. These cosmetic orders considered their case. What will they consider? These issues have implications, and the government would not like to part with finance unless they are compelled to under the law.
And Lordship,
The compulsion must first be under the law, which will be set in motion by the court order. So what is the compulsion under the law? The judgment must indicate that these are the reasons for which the government is duty bound to carry out these responsibilities.
No, Milord, I shall make them party. No, no problem, Milord. But
Lordship,
one thing,
Lordship, fact is that this union leaders or these petitioners, they were aware of these agreements.
Yeah.
One of the petitioner is a witness in the
No,
agreement.
but is the agreement on record?
The agreement record.
But
Agreement is on
the,
record.
but the entity is not a party here.
Entity is not a party. So earlier, in the earlier round of litigation, what has happened, they only came for the VRS. Now in the second round of litigation, they are bringing in the point of retrenchment. So that is
So
also.
VRS, how is it possible? VRS
It's not
VRS
possible.
operates in a different
So
scheme.
that has been rejected by the government also, because that.
So that
company
is
was-
under challenge here.
yes,
That is, they are challenging that also, because at that point of time, it was already MOU was signed. So if this company was never considered for VRS.
All right. Mr. Dasgupta, please consider this. Don't be in a hurry.
no, I'm not in a hurry. Milord. I
There-
filed
there are-
this case in the year 19
There are
2015.
There are two aspects here. If you say that you are only confining your submission to the correctness of the order of the government by which your VRS was rejected, then you need not implicate the other side as a party.
Right.
Then we'll confine our adjudication only to that. If we find that this order is in accordance with law, matter ends. If your claim is that whether or not VRS is valid, under the law, your clients are entitled to alternative remedy, which will flow from the statute. Then you have to implicate the other side as a
No, I
party.
am concerned with the money.
You are concerned with the money.
Money.
But
In
we are
what manner
concerned
I
with-
got the money, that I am concerned with
We
that.
are concerned with
The order,
justice in accordance with law.
with the law.
Now what
So
to,
all that, Milord, without taking any risks, Milord, I will impede them. And.
but you are free to argue that.
No,
they are not-
I will not argue that way by taking risks, Milord. But because I have prepared my case, but I will not take any risks. But I shall make them party.
If you make them party, then your scope of relief broadens up substantially.
Well, I shall make
What
them party.
happens to this? What happened to the plantain
No, one
machinery?
thing that I would like
The
to.
plantain mission is still there. Also, what has happened after this agreement was signed? So as per the agreement, these employees should have been absorbed by the new management. So they tried to absorb those people and live with new terms and conditions, but it seems there was no cooperation from the employees. So that's why the company could not revive. But in the record itself, these employees, they have formed an organization also. That organization is a part of the, witness to the agreement.
They are not parties.
They are not party.
It's a registered
So
organization.
that may not get, I'm not very sure about this, but like this, as a witness, they have signed in the name of the new organization, as an employees organization of that particular new organization.
And what is the name of that company? Which is,
Assam Yarn Suppliers, Assam Yarn Suppliers.
no, which company has taken over the
That
share?
Assam Yarn Suppliers,
That's a private company.
that's a private company.
Based
And
at,
and it was Assam Politics Limited was the government company. Assam Yarn Supplies is the private company.
so that means it's a complete transfer of the company undertaking by the previous owner, government company to a private entity.
So if this transfer takes place, Milord,
Hmm.
one thing that I would like to place before your lordship, though I shall make them party. Today, Milord. When a company is transferred to one organization to other organization, the concerned employees who are working in a particular establishment are entitled to have the retirement benefits. For that purpose, no industrial dispute is recorded.
All right, so there must be some clause in the agreement, transfer agreement, share transfer agreement. Where is that clause? That agreement is a part of record.
Yes,
Yes, Lord.
Which page?
Page 60 or something.
All right. Is there any clause there as to what will happen to the existing employees?
Yes, Lord. It is there.
Where is, which page?
Para 64, Lord, you will find.
Para or page?
Page 64, para 2H.
Hmm.
2H and 2I, Lordship, these are the relevant paragraphs.
the second party agreed to operate Assam Politics Limited under a new company herein after referred to as a company by way of sale, lease, rent. The government of Assam also agreed on the above terms, provided all the workers and staffs will be employed in the said new company. on fresh terms and conditions framed by the new company. The workers and the staffs are also agreed on the above terms by submitting letter dated 7/11/1997 to the government of Assam. On 7/5/2000, the workers again expressed their willingness to work on the terms of stated in their letter dated 7/11/1997 in a meeting held with the Honorable Minister of Fisheries, local MLA at Jagiro. The owners of fulfilling the undertaking of the workers mentioned in clause for the report, restart and subsequent operation will rest with the second party. In the event of the second,
No, I've seen it. Mr. Gogoi, you have a problem here. You will be hit by something. You have terminated their service
Yes.
before the handing over, before the transfer took place.
Yes.
How can you do that? Whether the new employer, new owner employs them or not will be a fresh arrangement. But that arrangement can happen only if it is treated that their services are terminated. It is not a continuance of service. You better obtain instruction on this. As per the agreement, on the date of transfer, they were all gone. Their services stood extinguished. You have to tell us under which provision of law it has been done. Now tell us that. Mr. Kalita,
Lordship.
what is your answer to this?
So, Lordship, usually, Lordship, what happens is that in a, if the company is taken over by a management, a second management, it's not termed as a termination.
No, but
Yes,
the agreement
because,
says,
because
it uses the word fresh.
yes, the fresh terms and conditions will be
Fresh
there.
doesn't mean continuation.
The fresh terms and conditions will be
Fresh
there.
terms and conditions means fresh appointment.
That is true, Lordship, but
Then what happens to their existing appointment?
So they are
the
entitled to
existing,
retention
the
for
Lordship, existing appointment remains because they will be absorbed by the new company. But
No.
obviously, like new company, they will take up these employees. They will have different liabilities. They look into the look into different aspect of the matter, and they will frame up their terms and conditions. That is what Lordship it says. It doesn't say termination as such, Lordship. Because in the second paragraph also, we Lordship will find that that it reads like this: the government of Assam agreed on the terms that the officers and workers and staff of Assam Politics Limited cannot claim any past liability from the Assam Politics Limited or the new company. So Lordship, and they have given a letter also agreeing to this terms and conditions. Their
Mr.
terms and
Dasgupta, your
So-
petition cannot be
So
decided.
there are
without
disputed facts.
because of this particular clause.
So if any,
Cannot be decided. Question doesn't have. We have to ask them what they understood. What is their understanding
so
of
there
things?
may be evidences will be required. So Lordship, at this stage, this
What
No evidence
evidence?
is required, Lord.
What evidence is
No
required?
evidence is required. It is
No,
admitted
because
You
fact.
are working.
No, Lordship, there will be disputed facts
No disputed
regarding what I'm saying is Lordship, because new company has taken up.
Yes.
Whether
you-
new company has offered them any job or not, whether they were willing to take them or not, those things has to
That is
come.
why they have to be.
Yes,
Well,
that detail will be executed.
Even assuming that the new company has not taken off, or we have not been absorbed by the new company. But the fact remains said that we have been terminated from the government company. And if we are terminated from the government company, that we are entitled to have the.
So
due
where
benefits.
is this? Where is the pleading that you have been terminated from the government company?
No, there's no-
Where is the pleading?
No, the staffs will be employed in the new.
No. Where is the pleading that they have been terminated from the
Well, let
government?
me check it out.
Yes.
Lord-
retrenchment compensation. When the retrenchment compensation takes place, I will explain later on that. Retrenchment compensation in accordance with the provisions of the section 25 FF of the Industrial Dispute Act, which stipulates section 25 FF compensation to workmen in case of transfer of undertaking, where a ownership or the management of an undertaking is transferred, whether by agreement or by operation of law from employer in relation to that undertaking to a new employer. Every workman who has been continuous service not less than 1 year in that undertaking immediately before such transfer shall be entitled to the notice and the compensation in accordance with the provisions of section 25F, or as if the workmen have been retrenched.
Now, what is sentenced here?
It should be retrenched. 25F. Okay. In the instant case, no workmen of Assam politics had received any compensation for the government of Assam. They have not received anything from Messrs. Assam.
All right. Now, how many petitioner? 138.
138. 138 out of this 138, most of the 138 is before your lordship.
So as per 25 FF and 25 F, retrenchment compensation.
Yes.
Have
That
you asked
much
for
I
that?
can get.
Have you asked for that? Have you demanded that?
Uh,
Huh?
No, actually, once I came before your lordship by filing a writ application for grant of VRS compensation, because the 2006 that was revived, but I could not succeed. And they say, no, we are not concerned with that VRS representation because the company has been transferred to a private entrepreneur, so we will not give it. Then, my lord, we approved before all that if you don't give the VRS compensation, at least you pay our retrenchment compensation because it is your case.
So where is the demand for retrenchment compensation? That's what I'm asking. You must have made the demand before the authorities.
That is, of course. Look, people should go to paragraph 8. Specific demand is not there, of course. The paragraph 8. The real fact of this case is that Assam Politics Limited is not producing anything. It has not been revived. It has transferred its 100% share to Assam Yarn Supplies to revive its production, but nothing could achieve. So the conclusion is that the public sector undertaking has been closed down with effect from 4/4/2001. In the event of this closure, the employees of the concerned establishment are entitled to retrenchment compensation, which is to be computed 15 days pay against each completed years of service.
Correct. So as per the case
provision-
projected by you, your clients are entitled to retrenchment compensation, correct? So retrenchment, let us assume that you are correct on the law, which usually you are. What will be the retrenchment compensation? There is some formula of,
Yes, no problem.
what is the formula? How many months wage?
Below, so far retrenchment just a minute.
15 days, you said.
If your lordship goes through the provisions as contained in section 200.
200. Yes.
Retrenchment has been defined. By read,
Just 1 second. RP. Yes.
Now, the term retrenchment has been defined.
Hmm.
Retrenchment means the termination by the employer. My employer is Assam Politics. Of the service of a workman for any reason whatsoever. Otherwise than a punishment inflicted by way of disciplinary action, but does not include voluntary retirement of the workman, retirement of the workman on reaching the age of superannuation if the concerned employed and workman concerned contains a stipulation in that year. So, when a person is
All
terminated
right, so
for
that is retrenchment.
That
How
is
to work out retrenchment compensation?
25A.
25 days, please. Let us go to that.
Well,
Yes,
no workman employed in any industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until the workman, number A, the workman has been given 1 month notice in writing indicating the reasons for retrenchment of the prior retrenchment and the period of notice has expired, or the workman has been paid in lieu of such notice wages for the period of the notice. It is not very important. Now here important section B. The workman has been paid at the time of retrenchment compensation which shall be equivalent to 15 days average pay for every completed year of continuous service or any part thereof in excess of 6 months. That is the compensation.
so you calculate what is
Yes,
the
yes.
retrenchment compensation your clients will be entitled to?
That can be calculated by them also.
Calculate.
Now we are.
The amount will not be very big.
It is
So
not
lots
very
of,
important.
Huh?
If you, my friend, want to.
No, there is one more.
But
thing.
one thing that just if your lordship comes to section 25 double F,
Yes, that's the important.
I want some solution, other has nothing.
So who will pay the
That is
replacement
defined.
benefit? That is
I'll
also
hear
there.
you. Hmm.
Now, section 25 F will guide us. May I read it?
Yes,
Okay. Compensation to workmen in case of transfer of undertakings. It is very much important.
yes. Yes, please.
Where the ownership of management of an undertaking is transferred. What has happened here? Whether by agreement or by operation of law, it has been done by an agreement from the employer in relation to that undertaking to a new employer. Now the private entrepreneur, new employer. Every workman who has been in continuous service for not less than 1 year in that undertaking immediately before such transfer shall be entitled to the notice and the compensation in accordance with the provisions of section 25F. Just now I have read it out. As if the workman had been retrenched. Now, provided that nothing in this section shall apply to a workman if in any case where there has been a change of employers by reason of transfer, if the service of the workman has not been interrupted by such transfer, it has been interrupted. The terms and conditions of service applicable to the workman after such transfers are not in any way less favorable. The question of terms and conditions does not arise because the company has not been divided. Favorable to the workmen than those of applicable to them immediately before transfer. And see, new employer is under the terms of such transfer or otherwise legally liable to pay the workman in the event of his retrenchment compensation on the basis that his service has been continuous and has not been interrupted by the transfer. So I would like to have this benefit only.
So what will be the involvement?
They are to compute my retrenchment benefits. The retrenchment benefit means the amount of salary which I due at the time of retrenchment.
Hmm.
15 days salary is to be computed for every completion of year of service. So as if I joined in the company in the year 1980 and the retrenchment took place in the year 2001, then 20 years. So I will get 10 months salary. But nothing else. And that will be paid by them.
What
That
is your
apart from my
response?
provident fund deposit,
Lots of-
etc., whatever be deposit.
What is your response to this?
Lordship,
These people have lost their job.
yeah, Lordship lost their job, that is correct.
10 months salary to 137 employees. Is it? It's not a very big
No,
amount.
Lordship,
Maybe 10, 15, 20 lakhs,
no, that is correct. Lordship.
or maybe 30 lakhs.
I agree with your lordship, but only thing is that government stand is that like, I have spoken to the government officers for last couple of days. I have been continuously in touch with them. So they are of the view that like since we have already transferred 100% shares and their name have been already registered. And there is in the agreement as well as the MOU was first signed, then there was an agreement signed. It was specifically written that the
All right, that is their view.
liabilities will be.
Their views are good for
That has
them.
been agreed. So agreement is that like liabilities will be taken by the new management.
No, that's correct.
Now
That's,
we have
that's
given,
the wrong view.
now,
view is-
now the thing
We'll
is that.
declare that it's a wrong
No,
view.
now,
That's wrong.
now thing is that lordship, that whether it's a retrenchment, if it is a retrenchment, whether this honorable court can adjudicate in the matter in the case of retrenchments.
Why we can't?
Because lordship, I have found couple of Supreme Court cases wherein as far as retrenchment is concerned, that's a benefit and right that is accrued under the Industrial Disputes Act.
Hmm.
So if it is accrued under the Industrial Disputes Act, then it should go to the industrial disputes for the relief. That is what Supreme Court has said in many cases.
How
Many
many
cases.
more years you want to make them run from pillar to post?
Lordship,
How many more years you want to make them run from pillar to post?
Lordship,
These people have suffered in
I
1994.
agree with your lordship. I fully agree with your lordship, but that
Please,
is what.
please
Supreme
don't
Court has-
argue that
the Supreme-
rate course should stoop down to that level.
No, that is not, no, lordship, what is
You
happening
know,
now?
if it is a straightforward case, then last year they have been retrenched, the matter is different.
Yes.
Since 94, these people are crying.
No, lordship, that is what lordship, in fact, lordship.
Obviously, you are not arguing that the rate court would not have
No,
jurisdiction.
what I'm
That
saying is.
you will not argue because that cannot be
No,
argued.
lordship, like what I'm suggesting and like submitting is that my humble submission, I have gone through some cases. And from there, like that.
That you argue, we'll
Yes,
deal
sir.
with the
That
argument. That's
I'll
not a
show you
problem.
lordship also.
See,
but
Mr.
what-
Kalita, those arguments you make it in abundance, we'll deal with it in the judgment in plenty.
Lordship.
Point is not that. Point is the court is only inclined to see if under the statute, something actually accrues to them under the statute, which was denied to them. This is number one. If the answer is in the positive, in the affirmative, then it has to be given to them. The next is by which forum? Alternative remedy, correct? Alternative remedy is a rule of prudence. There is nothing which divers a high court from exercising jurisdiction. That is the basic structure of the constitution. Nobody can either argue or come up with a law which prevents. These people have been, whatever be the reason, they have lost their jobs in 1994. You expect this court to now tell them that, all right, you have a right to go to the industrial tribunal and agitate this? Certainly, it's not going to be happening. You are free to argue. We will answer these questions. We are now moving ahead. India is moving ahead. We are moving ahead. Justice is not to be done only by the
I
court.
understand, lordship. I fully
What about
agree.
the government?
I fully agree with you.
They said that, all right, you take care of the liability.
I fully
They
agree
did
with
not
you.
take care of it for whatever reason.
I fully agree
Now,
with your lordship.
are these people not, they are only entitled to a 10-month salary as per the rate paid to them. Why would the court deny them that?
The only thing is that lordship, as far as like lordship has rightly pointed out that
No,
delay.
Mr. Kalita, you have a brief. We appreciate that. You have a brief, and regardless of whatever your personal stand is, you have to
Lordship.
cater to your brief. That is understandable. And to that extent, if you want to argue, please argue, we'll deal with it. But to cut the long matter short, these are the two aspects here. first of all, whether law recognizes any right on these people to get some form of compensation, which is statutorily recognizable. If the answer is in the affirmative, then they will have to be paid. The second question is, can the REIT court say that, all right, they are entitled to, but because it is an industrial dispute, you go to the industrial tribunal and set it up again. What will the industrial tribunal decide?
With my.
Once the REIT petition, REIT court says that they are entitled to, is there anything open for the tribunal? And then is today, how many years? More than 30 years?
With all humility, Lordship, the Supreme Court has stated that in case of retrenchment, that right has accrued from the industrial dispute act. So the forum is there.
We'll
That
deal
is
with
the
that.
problem.
We'll deal with it.
Yeah.
We'll honor Honorable Supreme Court's judgment and deal
And
with it.
as far as also delay part is
We
also
can
concerned-
always pass orders in peculiar
Yes.
facts of the case.
No, that is what Supreme Court says, Lordship.
That's the law. That's the correct law.
Point it out to your
That
Lordship.
is the correct law.
Lordship.
But peculiar facts and
Yes,
circumstances
sir,
of the
Lordship.
case,
Lordship may
we can
consider
take
those.
note of.
Lordship may consider.
34,
Lordship may
1994 and we are in
Yes,
2023.
yes, I understand.
29 years these people have been running from pillar to post.
The only thing is that Lordship, like, if the private party comes to the council board, then obviously like there are certain things they'll have to also answer, I believe, and Lordship will rightly pointed out.
We are not getting into that at all. We are not getting into that. The agreement says fresh appointment, fresh condition.
So Lordship, that is.
That is the clincher. That means the earlier arrangement is
No,
over.
Lordship, there was one thing that Lordship will have to appreciate, that this industry was never closed down. This industry was never closed down by the
No,
government.
it's
of
not,
Assam.
there is no requirement to close down. It's
There was
about
no-
transfer.
It was simply a transfer. So in case of transfer, as your Lordship has, my learned senior has already pointed out, that 25 FF, that proviso, if new entity takes up, then employees are appointed. But if their terms and conditions are not equal to the terms and conditions that they were working earlier, then only they will get it first. So that means what, that there are fresh terms and conditions will be made by the new employer. So in this case also, Lordship, the agreement was that fresh terms. and
Mr.
conditions-
Kalita, that industry never revived.
Yes.
So what is the point in making these arguments? We can't decide cases in thin air. An industry which was never revived, you expect them to employ them, the transfer company, they will engage them and give them work. It is never going to happen. We all
No,
know it.
Lordship, huge amount was in fact Lordship invested in that.
You please work out on what will be the amount payable to them. Make your arguments, we'll deal with it in our judgment. If they are entitled to, they must be given. If they are not, we'll dismiss the petition.
No, I can do one thing, Lordship, that I can obviously get instructions from my department that what will be the amount which will have to be paid in case of.
If the court holds,
That retrenchment is there.
yes.
That-
So now we have formulated the points. Let us put an end to this.
Yes, Lordship.
These agonizing litigations, but
Before
must
Lordship, like for formalize this points, 2-3 points, Lordship, I would like to argue.
Mm.
One is that Lordship waiver, whether they have waived their right, because they were aware of this agreement and the MOU. That is one thing, Lordship. Secondly, Lordship, the point of res judicata, because this 25 FF was never raised before in earlier litigation, Lordship. That is one point. And thirdly is, Lordship, if it is retrenchment, whether this honorable court will adjudicate the matter. These are these legal 3 issues, Lordship. I'll be based.
you can just make a short note of your argument.
I'll do that. I made a compilation of the cases. I'll do with your Lordship and make a small note of that. I'll do that. And in the meantime, Lordship, I'll take the instructions about the liability, what will be the
Yes,
liability.
if the court accepts it. So either it is ending in a mandamus or it is ending in a dismissal.
Lordship, I'll do that. I'll do that.
Beyond that, at the moment, the court is not thinking. Because let them have closure of their
Yes,
demands.
sir. No,
Either
we
it is
also-
this way or that way.
I also.
And I think 10 months wage at the rate of 1994 will not even be 10-15 lakhs.
Absolutely, Lordship, absolutely.
So what is such a big deal about it?
I'll look into
They
it.
were, after all, you are not disputing that they were your employees.
No, maybe I-
See, 94, 93, 92, government company used to be treated as a sarkari job.
Yes,
Nobody would have even imagined that they will lose their job.
absolutely.
So after that, whatever has happened has happened.
Correct.
But if the statute recognizes that they were entitled to some right, the only question is if court will consider whether by necessary implication they were treated to be retrenched employees with option, of course, to the new employer, but then the previous employer does not have any, you see, does not have any power over the transferee company. It is at their mercy. It is up to them. If they revive the company and don't employ them, then it is one thing. If they do not revive the company, then the question of employing them doesn't arise.
Yeah, that's understood.
So these are things we need not go into. If at the threshold, on the date of the transfer, these employees were having the character of retrenched employees, then the statute will kick in. Statutory provision will kick in. If it kicks in, then they will have to be given the statutory remedy. And of course, the forum. The forum you will see. You also get judgments on forum.
No.
But perhaps, depending on facts,
Yes,
circumstances,
correct, Lord. That is very
Each
much
court-
correct. That is very much
the
correct.
court
but
would have the plenary power to do complete justice.
Then Lordship, there is a case where what has happened is that similar, Lordship, I mean, around 14-15 years have passed. If like the matter was admitted, then at the time of final hearing, it was, this point was point was argued that so much of time has passed. Now, if it is sent back to the forum, then it will consume more time. In that case, also Supreme Court has
We
said.
will consider the judgment. Which citation, give it to
Yeah,
him.
I'll give you a copy, Lordship. I have made three comparisons. But I have made three comparisons. I'll give you.
You also look up. If the Supreme Court decision ratio is such that the writ court cannot touch, then it will be binding on us.
Definitely.
Then it will be binding on the court. Mr. Gogoi, you have been a silent spectator and a silent listener, but you are the one who will have the,
Finally, we'll have to pay.
huh?
Finally, finance department will have to pay.
So what is your response to this?
Here, my instruction is saying that, my lord, we have not received any proposal in this regard to consider.
So if a proposal comes, then you will consider.
Consider, it's only consider.
Then what is your problem?
That if they consider it, I mean, because there was no, I mean, representation from their side to the government as far as retrenchment thing is concerned. They were only seeking for VRS, and VRS Lordship speaking order was passed after the Honorable Court's order.
So anyway, now please consider, I mean, I don't think the involvement will be very big. It will be in few
It should not
lakhs.
be, Lord. Should not be.
Few
I
lakhs
have
only.
taken instruction.
It's a welfare state.
Lord.
You must stand by the people who have suffered.
No, yes, Lordship. Fully agree.
Technicalities,
My only
legalities are.
thing is that Lordship to just place before Lordship what is.
That's fine, that's fine.
Nothing else.
But we must have a balanced approach because
So, Lordship,
these
may allow me-
people
allow
must
me-
have suffered. Yes,
Yes.
when do you want it?
Maybe 2 weeks time, Lordship, 2 weeks time, Lordship may allow me.
Can you all agree on a date? And Mr. Dasgupta.
Lordship, 31st, 30th, something like that, this month,
March.
or March only.
Can it be fixed on 21st, Lord? Because there is a case.
The 21st, you need to give it. 30th,
Or
31st,
21st or 23rd.
30th.
Why don't you do it after 7th April?
That will be fine, Lordship.
As your Lord.
7th April is fine, Lordship.
11th April,
Yes, Lordship.
maybe a Bihu Bonanza, who knows?
That's
No
fine.
problem.
Yes.
11th April. is fine.
So by so Mr. A. Kalkan, and Standing Council Industry Department, and then Mr. B. Gogoi, and Standing Council Finance are present on behalf of the official this morning. On the request of learned council for both the sides, let this matter be listed again on 11/4/2023 as fixed parted matter, so as to enable the learned departmental council to obtain instruction as called for by this court.
Obliged.
Item 3,
Done. Oh, compresa ya. Kalau mau kali ini pun lo. Kita mau iyo.
Ito mo nito, patuloy lang ang kita case. Na copy na ako ng gising na ako nila ko. Mga kung copy na.
Well, I appear for respondent of 5.
Hmm.
On the last occasion, I sought for some time, my lord. My colleague appeared.
And no, Lordship has passed an order, my lord, since there is a delay on our part in filing the affidavit by the earlier date. So we will be debarred from, my lord, filing affidavit now. In the, my lord, I came to know about this order, my lord, today while I was going for a record. He could not, my lord, intimate me the exact, my lord, the order. I think I will have to, my lord, file one, my lord, I or miscellaneous application seeking the liberty, my lord. Because it's a matter relating to promotion. The respondent 5 is a, my lord, disabled candidate, my lord. He has been promoted in that particular quota only. Petitioner is not a disabled person. So otherwise, my lord, to challenge that part also, you will have to be in the same footing.
My lord, as per their own office memorandum, my lord.
No, what do you say on, he wants to
Yes,
file an IA?
So, sort, my lord, I will file the affidavit also, provided honorable court give me the liberty in that
No,
particular.
your right has
I
been struck
apologize,
down. You can always file an application tendering apologies, seeking, etc., etc. That is another thing.
Lordship.
But as of now, you don't, you're
Yes,
right
that's why,
to
my
file.
lord, I will have to
Stop
file it, my lord, by next week, my lord, I will file it, my lord, by any means.
My lord, it is always good, my lord, if the response come, my lord. But my lord, lordship may fix a date, my lord, so that they can file within that time frame. So 2019 meter, my lord.
Lordship.
No, not 19 matter, 2020.
My lord, promotion of 2019.
All right, date is okay, but when? Don't even look at March.
Thank you.
I'm not fixing any matter before 10th.
Madam, for filing their affidavit only, my lord, before last part of the March, my lord, before.
1 week's
Let
time.
them-
All right,
yes.
I had Mr. BK Dar, learned counsel for the writ petitioner. Also had Mr. B. Gokul, learned counsel for the respondent number 5, who has referred to the order dated 13/2/2023, passed by this court, and 6 leave to file an application seeking recall oblique modification of the aforesaid order insofar as the right of the respondent number 5 to file affidavit is concerned, which was struck off by this court. First, Mr. D. Bora, learned government advocate Assam, is present on behalf of respondent numbers 1, 2, and 3. On the request of Mr. Gugoi, this matter stands adjourned for a week so as to enable him to file the affidavit.
Item 4.
Kindly pass over for time being. Lordship.
My lord, in this matter, already sent for vetting, my lord, affidavit. We are going to file within 3 days, my lord.
You are appearing for whom?
Panchayat department, my lord.
You take the heard Mr. ABT Hawk, learned counsel for the petitioner, also had Mr. S. Daftar, learned standing counsel, Panchayat and Rural Development Department, Assam, appearing for the official respondents who submit that the affidavit on behalf of the department has been prepared and has been sent for vetting. First up, therefore, Mr. Datta seeks a week's time to bring the same on record by serving advance copy upon the petitioner's counsel. Prayer allowed, let the matter be listed accordingly. Huh?
Date may be fixed.
Date, this case again on 8th of May, 2023. Yes.
Oblige.
For hearing item 5.
Pursuant to the last order, the petitioner appeared before the medical board, my lord, on the 20th of February this year, my lord.
Yes. What happened?
Well,
He was not informed. Was just asked to leave after the examination.
the report they have given, sir.
No, why don't you give it to him? No, you give it to him. We'll take up the matter after
Yes,
some time. Let him examine. We'll call after, if we call at 12, 12:05.
Item 5.
The part-heard matter, my lord, Lordship would recall the petitioner was working as a 3F employee for 22 years, and similarly situated persons were regularized. And the records were produced, my lord. And from the records, my lord, it appeared, my lord, that both the three candidates, my lord, they were appointed and subsequently they were terminated and reappointed again, my lord. However, my lord, they say by way of a cabinet memorandum, the other two were regularized because they sat for an interview conducted by the APC in the year 1993, and my petitioner could not sit for that, my lord, interview, and that is the only reason why both of them were regularized, leaving the petitioner who were appointed together, my lord. This, my lord, in fact, they were appointed on the same day. They were terminated, reappointed again. There's no difference whatsoever, except the only difference, my lord, what they are trying to portray is that they appeared for a selection process, my lord, in the year 1993, wherein they did not even qualify. They were in the waiting list, and after
Private respondents are parties in this proceeding.
they are not parties because we are not claiming our appointment by,
But the only relief can be given is set aside the regularization of the other two.
If
What-
I
what are the
may
related
kindly
things?
suggest, my lord, what had happened, my lord. The lordship would see, as per the, my lord, the record which was produced, there is a cabinet memorandum, my lord. They say, my lord, inter alia, my lord, they say that these two people who were regularized, they appeared for that interview conducted in the year 1993, whereas the petitioner did not appear, and that is the reason why, by virtue of this cabinet memorandum, we'll be regularizing the service of the other two, leaving the petitioner behind, my lord. Now, from the records, my lord, what appears, page 24, from the order where the other two were regularized, it does not speak about the cabinet memorandum at all. It appears, my lord, rather, my lord, it is evident that they have exercised the powers under the office memorandum to regularize the other two petitioners, my lord, other two candidates, my lord. So, meaning thereby they must have realized that this cabinet memorandum or whatever, my lord, was, my lord, the deliberation, what had happened, may not be strictly in terms of law. Therefore, my lord, taking recourse to the office memorandum, they were regularized. Because the office memorandum does not speak about the cabinet decision at all. Well, I'll just read it out. What does it say? The notification, page 25.
Page 25.
Page 25. In
Yes.
pursuance of the Personal B Department's office memorandum so and so dated 16th March 2015. Now that is the office memorandum, my lord. The governor of Assam is pleased to regularize the services of one, Pallab Kumar Barua, two, Sri Prakash Bora, so and so, who have been serving under Regulation 3F of APSC, limitation function so and so, since December 1995 under the Directorate of so and so, with effect from 16th of March, with the following conditions. Now, my lord, they have taken recourse to the office memorandum.
No, Mr. Mohanta, I'm asking you, what is the relief that can be given to your client?
My lord,
What is the relief?
the relief what I am seeking, my lord, I may not be correct, my lord. But what I'm thinking, my lord, that since the other two who are similarly
They have
situated,
been wrongly done.
my lord, if they have taken recourse to the office memorandum, then yes, the power was there to regularize their services. And I being on the same footing, on the
No,
grounds
they
of
are
direct-
saying
my lord,
that these two other candidates had, according to them, regularization must be preceded by a PSC interview. That is the requirement of the rule.
that is what they say, my lord. But I do not interpret the OM in such a manner. I'll come to that, my lord.
So they say these two candidates had appeared before the APSC and therefore they have been regularized, whereas the petitioner has been left out. But the fact remains that they had appeared before the APSC in 1995. After that, their services were terminated. Then again, they were appointed on temporary basis,
All three of them.
all three of them. So the earlier appearance before APSC has lost its sheen. There is nothing left.
My lord.
This is a fresh process. Is their service regularized with effect from 1/12/1995?
Yes, my lord.
Huh?
16th of March, 1/12/1995.
So in between their service were terminated. They were
And
out
they were
of service.
reappointed again in the year
So then how it could have been done, we'll ask them.
Yes.
We'll ask them.
But
So it seems they have done all kinds of things with regard to these two candidates. The service law, the rules have been thrown into the windmill. But when it comes to your client, it is a different approach, be that as it may. But if appearance before APSC is a sine qua non, then it has to be done, is it not?
Exactly. But-
And when the opportunity was there, your client did not appear. Why?
My lord, because at that point of time,
Hmm.
the office memorandum where they're trying to say that appearance before the APSC is a sine qua non. It was not at that point of time in the year 1995. I was never told that you appear 1995, 20 years later, that appearance would come in the way of regularizing your service. But thereafter, my lord, it's my pleaded stand, my lord. In 95, my mother was sick. I was in New Delhi. And thereafter, there were two more chances, but the second chance was only for scheduled caste for reserve category. And I being a general, I could not appear. And second time when the interview was conducted, we already crossed the age limit. So we could not have, now my lord's come to find out a middle way, what I'm suggesting, my lord, with all due respect. My lords, a public order has to be construed publicly. Now, the record may say something that there is a cabinet decision, but nonetheless, regularization of the other two persons were done on the basis of the office memorandum. Now, Lordship would see
Which office memorandum?
office memorandum is, my lords, page 26. Now, Lordship would see that if I'm qualified in terms of the office memorandum, that I should also be given a similar, my lords, I'll read page 26, I'll read it out, my lords. May I read, my lord?
Hmm.
May I read? It's dated 16th of March 2015. The subject is appointment under regulation 3F of APSC limitation of functions and one-time measure for regularization of certain such appointees. Various departments of the government of Assam from time to time exercising powers under regulation 3F of APSC so and so, referred to as regulation 3F, gave appointments to various candidates to tackle emergency situations faced by those departments. Many such candidates, initially appointed for 4 months under the regulation 3F, are continuing in services year after year in an ad hoc manner without regularization. All these candidates have already crossed the upper age limit specified for appearing in the interview. This is very important, my lord. Stroke test held by the APSC for the post that they are holding and therefore left with no chances to get regularized in the post. Now, this second paragraph, it defines the class of people who will be entitled for regularization. And it says those people who have already served for a long period of time and in the meantime, they have crossed the upper age limit to appear before the APSC or sit for an interview for that matter, my lords. Third paragraph, my lords. Evidently, this situation has arisen mainly due to unwarranted exercise of power under regulation 3F by departments, failure on the part of the APSC to hold interviews in timely manner, and also the failure on the part of the departments to move APSC for regular recruitment. So the next paragraph is coming in my way, my lords. As communicated by the concerned departments, all these regulations or all these regulation 3F appointees now under consideration are working in regular vacancies, mainly under various orders of the High Court and drawing their regular salaries as admissible. However, those cases where the incumbent concerned have not appeared the APSC, test stroke interview, and those whose cases are sub judice are outside the purview of this OM. Now, there is this one line which says, my lord, have not appeared the APSC. Test or interview. Has not appeared. Okay. The APSC test and interview. Now, in my humble submission, my lord, to reconcile the entire OM, that line has to be read down. Because the class of people for whom, my lords, the OM was applicable was only those people who have already crossed the age limit. So therefore, they could not have anyway, my lord, sat before the APSC. The object of the OM itself was to regularize those people. Well, if,
So which paragraph of this OM comes to your aid?
my lord, the entire OM, except, well, sans the one line, have not appeared the APSC. Well, a paragraph, the fourth paragraph, income when concerned, have not appeared the APSC test and
No, these
interview.
are the background narration. What is the decision? Which decision of the OM comes to your aid?
Well, the second paragraph, and as per this OM, the other two were regularized, similarly situated, appointed together.
Second paragraph means paragraph which begins with,
Many such candidates.
all right, we'll have it after you. You are not answering my question.
My lord, I'm
These
so
are the
sorry,
background recitals.
my lord, my lord,
What necessitated the government to come up with the OM?
my lord.
But what is the decision in the OM which affects your client positively or negatively?
The only, my lord, that is what I'm assuming, because they are saying, my lord, that you have to
You
appear.
keep assuming till Bihu. Your assumptions are not enough.
But lordship would give me the specific question, I'll come up with the answer.
No, I am asking you, what is the mandamus and under which provision is, under what principle it can be issued? I do understand that there are some anomalies,
My lord,
but you want a mandamus
my lord, exactly,
because the other two have been treated in a particular manner.
my lord.
But the court finds that their cases also have been wrongly dealt with. Their cases could not have been considered on the basis of appearance before APSC in 1995 when their services were terminated.
My lord.
So therefore, two wrongs do not make a right.
Exactly, exactly.
So either the court will have to set aside their regularization and say that make similar consideration for which you have to make them party.
Sir,
There is nothing called negative
equality.
equality.
I understand, I'm not claiming negative equality.
So if you are not claiming, then the
My,
fact that others have been wrongly done,
my lord.
does it give a right to you to seek a mandamus? That's the question I'm asking you.
What I'm trying to portray, my lord, with all due respect, my lord, I'm trying to submit that in terms of the OA, I'm eligible and appearance before the.
Which is the particular sentence? The OM says these are the problems which have happened. People, APSC did not conduct interview, people are overage, etc., etc., etc.
My lord,
Now, therefore, where is that?
my lord,
Lordship,
that is page
Yes,
27.
Lordship, no, allow me to, Lordship, page 26, paragraph 2, my lord. This picture is very much clear that where it will applicable. Many such candidates initially appointed for 4 months under the regulation PF are continuing in the service year after year in the ad hoc manager without regulation. All these candidates have already crossed the age limit. Specified for appearing interview test held by the APSC for the post that they are holding and therefore left with no chance to get regularized in this project.
So they will be allowed to appear. Where is the decision?
But suppose APSC examination is there.
No, you are not understanding the question. You are again and again referring to the
Page 27, the next
To the-
page, if it helps, one
to
clause.
the
my lord.
prefatory facts. I'm not asking for the prefatory facts.
Well,
What is the decision in the preface of this fact? That's what I'm asking.
Page 27, the next page, my lord, just for a moment, my lord, clause 6, Roman 6.
Hmm. Yes,
The list of employees appointed under regulation 3F who have been considered here as an exceptional case and one-time measure for regularization as appended at Annexure A and who have rendered services varying from 9 to 22 years shall be regularized with immediate effect, subject to the condition that, these conditions were laid down.
so you are seeking the benefit of this particular clause.
OM, yes, yes.
That's what I've been asking again and
I'm so
again.
sorry, my apologies. my lord, I think
So why this benefit should not be given to the petitioner?
My lord, so far, my stand is concerned on the mines and minerals department, my lord. There are two situations, one is APSC part and another is my lord, that OM part. Now, Lordship, while we have dealt with this matter, my lord, we have wrote a letter to the, my lord, written letter to the judicial department, their observation. Lordship, just have a look to our affidavit in operation that we have filed, Lordship. It is the affidavit on behalf of the respondent number 3, my lord, filed by GS Paneshwar.
Yes.
My lord, page 8, my lord. Page 8. Now, the observation is such way, my lord.
Yes.
My lord, that Mines and Mineral Department OA, and this letter was written by Deputy Legal Remedies Assam Judicial Department. Now, Lordship, second paragraph. Now, this OM is not taken into consideration and alike my lord, page 9, my lord, personal department also declined, my lord. My page 9, the personal department also made the same observation. So their focus was basically on APSC, my lord.
Yeah, but there is a March 2016,
Yes, my lord.
which says people who could not
Valid,
appear before the APS.
Because this observation was made on 29/5/2015, personal department. Afterward, my lord. Perhaps suppose, my lord, they have not taken into consideration this aspect of OM, my lord. They put their eye only on that APSC aspect, my lord.
So what he is saying is the other two, their appearance will
My-
also be treated as null and void. Because after that, their services have been terminated.
My lord.
What do you say to that?
My lord, that appointment letter, what my learned friend referred about these two persons, that says about regulation in terms of OM, my lord.
Hmm.
Now, these are the gap, my lord.
And other similarly situated people all over the state were regularized. I have appended it, madam, page 41.
And this
And I'm
person
saying, my
already
lord,
retired, my lord,
Page 41, madam,
in 2022.
by virtue of that OM, madam.
They also did not appear before the
No,
APS.
no, that's not even a requirement, madam. In persons of government OM issued by personal B department by so and so dated 16/3/2015 and after proper examination, verification pertaining to their eligibility in terms of their educational and other qualifications as required at the time of their initial appointments in regard to the post they are now holding, the services of the following subject teachers, demonstrators who were appointed under 3F so and so are regularized against the post they are currently holding with immediate effect.
Without APSC.
Without APSC. Now, my lords, with all due respect, my lord, if that is read in, that you have to appear before the APSC, the entire OM would become redundant and obvious, my lord, because the OM defines a class of people who will be regularized. And that class of people includes those people who have already crossed the age limit because they were working under 3 years.
And what about your client is not in service since 2016?
No, my lord, that is palpably false because I have pointed out on the other day, my lord, from the affidavit itself, the department itself was assigning duties to the petitioner till 2018. Thereafter, when she stopped receiving salary, she approached this high court. And
Approached the High Court and is
this same matter, my lord. And after approaching the high court, she was not allowed to come to the office, my lord. Therefore, we filed an interlocutory application wherein there is an interim order which says that I should be allowed to come to the office. And thereafter, in the meantime, while the case was pending, I superannuated from service, my lord.
Actually, you already superannuated.
Superannuated. And my lords, I have shown, my lords. the
When did
department
you retire?
January 22, my lord.
31st of January 2022. And I have shown, my lord, documents from the department wherein, my lord, each and every document, it says that my services are required. That please regularize her. She's efficient. She's a first class geology working for such a long time. We need her services. You need to regularize her services. And in spite all of that, my lord, my service was not regularized. And now,
Can you just give a written note of your submission?
my lord.
You want to argue anything or? All right, then I'll come back. Once again. So first is 1st February 1993.
93, the date of appointment. My lord, there, my lords, page 19. I am at serial number 2. 3 and 4 are the other two persons in the same post who were regularized on 2/5/2015. Thereafter, my lord, annexure to page 22, the last extension was till 31/7/2016. Thereafter, my lord, on 16th of March 2015, the office memorandum was issued, my lord, which your lordship would find at annexure number 5, page 26.
No, what about 2nd May 2015?
Thereafter, my lords, the other two persons were regularized on the basis of the office memorandum.
Yes.
16th of March, the OM was issued, my lords.
Hmm.
In the month of May, 2nd of May, the same year, the other two persons were regularized, my lords, invoking the office memorandum. Now, thereafter, my lords, page 26, my lords, there's a letter by the Minister of Mines and Minerals requesting the additional chief secretary to regularize the service of the petitioner since he's been serving for a very long time.
That is page 29.
Page 29. Hello. The fourth paragraph, in view of her long service of more than 22 years in the directorate and adequate experience, she deserves to be regularized in her service immediately, even in relaxation of the existing provisions of the department for such regularization. Thereafter, my lords, may kindly turn the page. This is a letter by the Director of Geology and Mining to the Joint Secretary, Government of Assam, Mines and Minerals, where again, my lord, the same request was forwarded. And the first paragraph, last line, besides these, the directorate is running with shortage of manpower. So her services were under the above ground. I would like to recommend her service for regularization from your end. Thereafter, my lords, representations, my lords. Page 31 to 33. There are, my lords, 3 number of representations, my lord, by the petitioner for her regularization, my lord, to the authority. I'm not referring to all the representations, my lord. Thereafter, my lords, page 34. There is an office note, my lord, of the department. Lordship would come to the notings, my lord, the second noting, second paragraph, Mines and Minerals Department, UO. The department is advised to decide about whether they need the services of the incumbent any further. In that case, her services should have been extended. Now, the fact that her services were required has already been stated by the director, my lord, which I have already shown. That is Annexure 7, that her services were required. Thereafter, my lordship would turn to page 41, where other similarly situated persons, my lord, in the education department, taking aid of the same office memorandum and without the criteria of sitting before or appearing before the APAC, were regularized, my lord. There are 38 in numbers, my lord. Page 41. Thereafter, my lords, these annexures would help to show that she was in service even after the period of extension, last date of extension. Lordship would turn to page 45 for a moment, my lord. There are 3-4 annexures, my lord. Page 45. This is a letter dated 29/11/2016. Please find herewith the list of officers nominating for the work of District Mineral Foundation Trust, issued by the director. If your lordship turns the page, at serial number 23 is the petitioner. Serial number 23, the petitioner.
Yes, I've seen it. Yes.
Then my lord would kindly come to page 47, my lord. Another letter, my lord, 24/10/16, again by the directorate. Well, I won't take much time, my lord. Just the first line. please find herewith the field program of the Directorate of Geology and Mining. If your lordship turns the page, my lord, the program is there, my lord. B, project 1, the right side column, my lord, the extreme right column. Personnel and equipment, lordship has it, my lord. There, my lord, lordship would find the name of the assistant geologist, the petitioner, Srimati Anusia Paul Basu. Then again, my lord, would kindly turn the page, my lord, page 49. This is a letter of 7/7/17. The following officers are hereby entrusted to the respective committees for so and so. The second, my lord, serial number 2, numerical 2, preparation of folder material, there, small d, Srimati Anusia Paul, geologist. Now page 51, my lord. This is a letter dated 5/10/17, and it's by the same director who has sworn the affidavit in opposition, where he says that she did not come to office after the year 2016. My lord, here lordship would find, please find here with the field program, my lords, and lordship would turn the page. The right column of the table, personnel and equipment, Anusia Paul Basu, assistant geologist. So if she was not visiting the office, well, it is highly improbable that a director would assign her duties, my lord.
So what is the date of the interim order?
The date of the interim order,
Interim order is passed in IA.
IA, my lord, passed in the IA. Interim order, my lord, is. I have a copy. My lord, it's dated 14/5/2019. The third paragraph, the authorities may not dispense with the service of the petitioner till the next date fixed, as all others who have been appointed along with her have been continuing in service, and some of them even regularized, my lord.
So she continued in service,
Until her superannuation, my lord.
which is 31st of January
31st of
2020.
January 2022. A few more annexes, my lord, just the additional affidavit.
Yes.
will also take time. So here it's a letter by the Director of Geology to the Additional Chief Engineer at page number 5 of the additional affidavit, my lord. It's dated 20/04/2021. And the second paragraph,
Yes.
considering her long service, this office again recommends her extension of service. Lordship would see the last 30/11/2020. There is a recommendation by the director in the year 2021. Again, my lords, the next page, again, the director forwards an application to the secretary. Last paragraph, my lord, considering her long experience of almost 25 years and also expected date of her retirement at January 2022, her prayer for regularization may be considered sympathetic. To be fact by the director that she was not attending office from 2016 totally stands belied by the document what I've showed to your lordship. In fact,
So where is that statement in the affidavit filed by
affidavit filed by the Mines and Minerals, well, I'll come to that one.
respondent number 3?
Respondent number 3. I'll refer to them. This is filed by Mr. G.S. Panesar, my lord. The 5th paragraph. Fifth paragraph, the last 3 lines, my lord. However, it is pertinent to mention here that neither the petitioner did attend the office nor performed any duties, though she was asked to do so after 1/8/2016. but there are letters till 2021, wherein her service was counted. The 25 years, 23 years she's been working. And again, my lords, page number 3. Last 6 lines. While Srimati Anushya Paul not having been appeared recommended by the APAC, her case cannot be considered for review. That is the only thing, my lord, and they do not come up with any logic or reasoning.
Yes.
And my lord, my submission on merit would be, my lord, that to give a purposive interpretation to the office memorandum, the line, my lord, which says have not appeared the APAC has to be read down, my lord, because if it is not done, my lord, the entire object, the entire foundation of the OM would stand redundant, my lord. And that is, and to substantiate that point, my lords, others I have already shown 38 people were regularized without appearing before the APAC. And again, the other 2 were also regularized on the strength of the OM, although they say they appeared in 1993, my lord, which in my humble submission they could not have done, my lord, because their judgments to that effect, where a validity of a waiting list or in the selection process would be valid for a period of only 1 year. And they were in the waiting list.
And where is the document to show that their services were terminated after that?
That documents, my lord, we didn't have the document, even in the affidavit in opposition, they did not state that, my lord. On the last occasion, when your lordship perused the records placed by my learned friend, it appeared, my lord, there was a cabinet memorandum, my lord. I have a copy, my lord, of the exact portion of the lordship. Here, my lord, they say they were appointed, terminated, appointed again. Then we went to the High Court, there was an interim order. That interim order culminated in a final order in the year 2006, where the High Court said, my lord, directed that it is your wish if you want to continue, you continue with them. But nonetheless, my lord, it appears that we were continued from 2006 also, my lord. Well, I'm very sorry, I tried to locate the records of the case, my lord. It's not in the website, my lord, because it's a old.
All right. That's all.
Yes, and my lord, if they try to say that the other 2 were regularized because there was a cabinet memorandum, on that point, I would like to state, my lord, Govardhan Das Bhanji and the subsequent judgments are, my lord, no longer, it's no longer res integra. The public order has to be construed, my lord. There cannot be any explanations after the order has been passed. And the order of regularization clearly says that the powers under the OM were invoked. So, by that, my lord, I am also entitled, because I say, my lord, that appearing before the APAC is not even a sine qua non of the OM. That's my solution.
Lordship, if your lordship peruses to the order.
First, tell me what is the formality argument first.
Your lordship, basically, as I have placed on last occasion, as my learned friend had placed, since I gave him a copy of their office memorandum based on which the other two people were regularized. Now that was not done, not on the basis of a cabinet memorandum. There existed a office memorandum to that aspect of 2011, and after that, the regulation was approved. But this was not the case with only with mines and minerals departments. There were other 11 departments. So all of this were actually happening in a very haphazard manner. Some people from certain 3F appointees were being appointed and regularized, and others proposals were sought for from the department, but the departments were not forthcoming with their proposals. And so there was a very haphazard manner it was being handled by the department, by the government. So the government, for once and for all, they took a decision based on the advice of the learned advocate general that basically a one-time regulation measure should be adopted and let a OM be passed. This is the OM of 16th March 2015. And after passage of that OM, no more 3F appointees will be regularized. And certain conditions were laid down in that OM itself. And I have on last occasion on 4/1/2022, your lordship actually wanted to know the motive, the background story behind passage of this whole OM dated 16/3/2015. And that's why I wanted to place that office cabinet memorandum based on which, after which that OM came into force. And in that office memorandum, these two appointees cases were also discussed as to how they were first approved, they were regularized, but later on, a formal streamed down measure after the passage of the OM should be adopted. And after the passage of the OM of 15th April 2015, then only the two people, they were regularized. Because as my learned friend said that we should rely on the Gopardhan Das Bhanji case. Yes, because if the regulation order speaks, the regulation was done only in terms of the OM dated 15th March 2016. 16. So based on that OM only.
Which paragraph of that was used to regularize the service of other two? Can you point out the paragraph, please?
My lord, page 25.
Yes. No, that is mentioned in their order of regularization.
Yes.
But which paragraph of the OM dated 16/3/2015 was invoked to regularize them? Which paragraph?
Because paragraph 2, because however, paragraph 4, however, those cases where the incumbent concerned have not appeared the APSC test or interview, and those whose cases are subject.
No, you're reading from which page?
Page 26, next page.
Page
from the
26.
Because the OM is a culmination point of all the decisions taken. Paragraph
Yes.
number 4.
Yes.
Because they have appeared once in any APSC test or interview.
Evidently, this situation has arisen. You're reading from there.
After that, your lordship.
Yes, then
As communicated by the concerned departments, all these regulation 3F appointees now in the consideration are working in regular vacancies mainly under various orders of the High Court and drawing their regular salaries as admissible. However, those cases where the incumbent concerned have not appeared the APSC test or interview, and those whose cases are sub judice are outside the purview of this OM. Now, since those two people, they had appeared once, even though they did not get selected, but they appeared. They were taken into consideration and they were regularized. Now, the case of the petitioner is different because she never appeared in any APSC test or interview. And now, instead of challenging this OM, what he is saying is basically an expungent.
You are sure that these people
Yes.
whose name find place in the notification page 41, all of them had appeared before the APSC.
Not
Page
page 41, your lordship. I'm not so sure of this because it's a notification issued by the Secondary Education Department.
That's right. They were all appointed under 3F.
No, your lordship, because all the 3F appointees.
So what do you mean? No, it's written in the notification.
No, these are later on, after passage of the OM. This is 17th November 2015, your lordship. These are of the secondary education department.
Mhm. So these are not in terms of 16th March 2000.
Same.
15. This is 16 March 2015,
Yes.
and this
so
is later on, 17.
That is what he's saying.
That's what.
Because of that OM, these
Yes.
people have been regularized,
Yes.
but
these
they
are-
have not appeared before the APSC. That's what his claim is.
No.
The OM was for the entire state of Assam. Different departments have regularized different. 41 clearly shows melody. And even the recital.
Your Lordship, nowhere in this order as such says that they have not appeared in any APSC. They have just, it says, the language is such, in pursuance of government OM issued by personnel department dated 16/3/2015, and after proper examination and verification pertaining to the eligibility in terms of educational and other qualification as required at the time of the initial appointments in regard to the post they are now holding, the services of the following subject teachers and demonstrators who were appointed under Regulation 3F of APSC Regulations 1951 are regularized against the posts which they are currently holding. But the
So
order,
according to Mr. Mohanto, these candidates never appeared before the APSC. Is that,
Yes,
have you made that statement?
yes, my lord.
Where is it? Which
So
paragraph?
this statement,
this has to be verified here also.
The statement is in which paragraph?
I'll check whether that statement is there, because originally when the writ petition was filed, this point was never taken, my lord, because the others were. I only came to know that the other two persons were regularized, and they were regularized because they appeared in the interview after they had filed the affidavit in opposition, my lord. I was not.
No, but that is what you argued today.
Yes, my
That
lord.
these 38 candidates have been regularized.
Yes,
They are similarly situated.
yes.
Where is the statement?
Your Lordship, page number 10,
That the
paragraph
statement.
number 9, where they have annexed this particular page number 10 and paragraph number 9 of the writ petition. Nowhere speaks that yes, they were regularized, but they never appeared in APSC. If they can show from this,
No, I could not have, my lord, because in paragraph 9, where I've appended the, my lord's, that notification which I've shown, that was appended to show that other people.
That's all. I just want to see. The OM says those who have not appeared and those who are continuing due to High Court orders will be outside the purview of this OM.
My lord.
Does it not say so?
Yes, those are who have not appeared.
So therefore, your client did not appear.
Yes,
So the question is, unless there is some OM which covers her case,
my
it
lord.
appears 16/3/2015 does not cover your client's
My
case.
lord, in my humble submission, my lord, that is why I have requested this court to give a purposive interpretation to the OM. Because,
Purposive interpretation is of statute, not.
my lord, even, my lord, I'm so sorry, my lord, place that judgment, my lord. I had this judgment, I couldn't find it now, my lord.
Hmm.
My lord, lordship would kindly read paragraph 2. Now you have to reconcile the OM, my lord. Paragraph 2 is totally contrary to paragraph 4. Paragraph 2 defines the class of people who are eligible. Now, my lord, logically, my lord, if I had the age limit to appear before the APSC, the OM would not have been issued at all. I'll read it out, my lord, once. Paragraph 2. Many such candidates initially appointed for 4 months under Regulation 3F are continuing in the services year after year in ad hoc manner without regularization. All these candidates have already crossed the upper age limit specified for appearing in the interview test held by the APSC for the post they are holding, and therefore left with no chances to get regularized in the post. Now, paragraph 4, the paragraph itself is so badly drafted, my lord. Even the semantics, my lord. What does it mean, my lord, when it says have not appeared the APSC test or interview? The OM itself is for people who have already crossed the age limit to appear before the APSC. The class of people is defined in paragraph 2. And lordship, again, I'll read paragraph 4. It does not even make any sense. As communicated by the concerned departments, all these Regulation 3F appointees now under consideration are working in regular vacancies, mainly under various orders of the High Court. It says they're working because of the orders of the High Court. In the same breath, my lord, they say, and those whose case are sub judice are outside the purview of the OM.
In para 27, Roman 6,
Para 27, my lord.
yes, Roman 6 of that OM.
Yes.
It says list of employees appointed under regulation 3F
Hmm.
who have been considered here as an exceptional case and one-time measure for regularization as appended in Annexure A. Where is that Annexure A?
Annexure I couldn't find, my lord.
That is there in the cabinet memorandum, Your Lordship. I have to again show because
And 9 to 22 years also I satisfy, my lord. And appearing before the APSC has to have some meaning, my lord. Cannot be a useless empty formality. You appear, you fail, you be in the waiting list, after 20 years, they'll consider it.
no.
Lordship may also tally the names with the 41
Yes,
page,
just
41
1 minute.
notification.
So in the mines and minerals department, it shows that two were considered, excluded those who have not appeared in the APSC interview, two.
Yes.
Included those who have not appeared in the APSC interview, two. What does it mean?
Those two, in the annexure A. Under first serial number, mines and minerals, those two were appointed. And the appointment order is at page number 25.
Yes, but they appeared before the APSC in connection with some other process. Subsequently, their services were terminated, and 22 years later, they were regularized.
They were regularized,
How can it be done?
but at the same time, your lordship, this was actually one-time measure. This was a one-time measure. Even the case of the petitioner were also taken. But she was not selected because she never appeared before any APSC test or interview. So her case was rejected. Only those two names, there were three people.
That's correct, but what do you mean? Somebody spent 25, 26 years in service. And not regularization means you don't want to pay the pension. Don't regularize, but pay pension and other service benefits.
But
That's all we'll order.
But basically a policy decision was taken. A policy decision was taken in terms of the cabinet decision. In terms of the advice of the learned advocate general of the time. To take a policy decision, to take a one-time measure to regularize those
That's
three
all right.
employees.
Nobody is questioning that policy decision.
So that particular decision was taken, even though, yes, their services are terminated in the middle, then they approach your lordships, and again they were protected, and that continued, then ultimately it was disposed
So
of.
now for the petitioner, she has already retired. So regularization will mean pension. Is it not?
Now
else?
only pension will only mean.
What else? Nothing else.
Nothing else.
So regularize or not regularize, pay her pension. That's what will direct.
Keeping out the.
After
merit-
25, 27 years of service, how can you say you are not a regular employee?
Then your lordship may kindly observe that she may not be, she is not regularized per se. But for counting for pension and services, but then again, the finance has to say, we are not in a
In
position.
that case, my lord, there will be a target. Tomorrow everybody will come, my lord, I work for so and so as a contractual employee, be a master worker, my lord. They should be given pension. That will again be, my lord.
No, every
Because my
order
lord,
is
3F
for-
appointment is pursuant to a particular rule, my lord. If the rule does not permit for pension, my lord. In that case,
So Mr. Gogoi, see, this person was appointed along with two others pursuant to a selection process.
lordship,
That was 3F appointment.
yes,
These 3F appointments are normally to be for a period of 4 months.
4 months,
But their services were extended from time to time.
lordship,
And several occasions, recommendations were made.
lordship.
And up to 2016, the government also said that if you want to
Extended, yes.
extend it. So 93 to 2016 is 22 years, right? Then suddenly, two of the three candidates are regularized.
Mine,
Why? Because in 1995, they appeared before the APSC.
lordship.
Now, appeared in what connection? The APSC appearance has to be for the purpose of regularization in the present service.
Yes, my lord. That is the,
That cannot be, that has to be linked with the process of regularization. That appearance was for something else. That was 22 years back.
my lord.
After 22 years, how can you treat that as a process?
So, my lord, that part can be questioned only when this particular OM is put to challenge. May I submit, my lord? The petitioner service was last extended in 2016. And thereafter it has not been extended. The region lordship will find it in page 27 of this OM. Yeah, my lord, it's the Roman 5 para. Personnel department shall not allow any further extension of the term of any employee appointed under regulation 3F, which exceeds beyond 6 months from the date of issuing of this OM, and will take up the matter with each of the department and APSC for advertisement of such posts within the stipulated time. There shall be no person appointed under regulation 3F with effect from the first day of December 2016. In fact, my lord, probably for this, after this OM, my lord, it was not extended. And secondly, my lord, Lordship may see the prayer made in a writ petition. The petitioner has prayed that my lord, her arrear salary should be released along with the current salary. Meaning thereby that my lord, she was not in service, my lord. After there was no extension, she was not in service. That's why my lord, she has come up with all this, my lord.
So there is no prayer for regularization.
There is, madam, there is.
No, regularization part I'm not saying.
First prayer, madam. To direct the respondent to immediately regularize the service.
The second prayer, my lord. A writ of mandamus should not be issued directing all the respondents to release the outstanding and current salary. The period has not been mentioned. For what period, my lord, that arrear salary is due?
That I have mentioned in the pleadings, madam, in the prayer.
No, Mr. Gogoi, tell me one thing. Technically, it is, let the government also not take that be too much because
But
technically
that part, what I submit. I would like
25
to
years
submit.
of service, 22 years of service, and then you say that,
My lord, this
sorry, we
particular
don't know who you are.
whoever has been regularized was pursuant to a cabinet decision. So lordship may indicate everything and leave it to the cabinet to take a call. Let it be placed before the cabinet in the case of the present petitioner.
No, but cabinet decision also, it takes into fold the ad hoc employees in the mines and minerals department.
My lord,
Then why the petitioner should not be included in that?
my reason is, my lord, obvious, my lord, that particular ground that my lord, in her service career as a 3F appointee, she never participated in the APSC selection. Despite my lord's selection being held from time to time. That's the reason, my lord. And that's the sole criteria of preparing that list, my lord. That list annexure A mentioned in the my lord OM. Now, if at all lordship feels that my lord she should ought to have been my lord considered, lordship may indicate the authorities with certain observations why she should be included. And let them take a call, my lord. Including my lord, if not possible for pension part. With the observation, my lord. Let them take a call. If they take a call, my lord, tomorrow, then every others will also be entitled because it's a government who has taken the decision, cabinet decision. There may be observations to that effect. But if a mandamus is issued, my lord, tomorrow, my lord, everybody will come. That's the issue. Doing the, my lord.
No, take a call means reject it. And then again she comes, something like that. What is troubling me is 22 years of service.
My lord,
And this is not a masteral worker,
my lord, she has accepted.
qualified. Huh?
She has accepted it. She knows what is her position.
Hmm.
That she is a CF appointee. She on her own continued. Even there was no endeavor on her part to go for a regular job. She was happy with 3F. That's why, my lord, this clause has been point has been mentioned in the OM. That, my lord,
No, was there any APSC advertisement during the period of her service?
My lords, I have specifically stated, I'll quote from my pleadings, my lord. Lordship had inquired two questions, my lord. First, whether I have mentioned that the OM was misinterpreted, that appearance before the APSC was not a sine qua non. And second, Lordship has said, why didn't I appear, my lord? The reason, Lordship, may kindly take up my reply for a moment, my lord. Paragraph 7, my lord. And my lord, with all due respect, the reason that it will open the floodgates is not a valid submission, my lord. If I'm entitled in law, I'm entitled, my lord. I am being vigilant. I have approached this court. Others have not being vigilant.
No,
They
just a
would keep
minute.
us under 3F for 25 years. Now they cannot come and say that I did not. Paragraph 7 of the affidavit in reply. That in
Paragraph 7.
paragraph 7.
Yes.
And the submission, my lords, that I was attending the office by my own, that is also, that does not have any legal standing because there's an interim order, my lords, where there's an order not to dispense with my service. Paragraph 7, my lord, that in respect of statements within paragraph 6 to 11 of the affidavit in opposition, the deponent humbly begs to state that the respondents have misinterpreted the OM dated so and so. The intention behind the formulation of the said OM was to regularize the services of those candidates who have continuously working year after year in ad hoc manner and have crossed the upper age limit for appearing in the interview test held by the APSC. It was also reflected in the OM that such situation mainly arose due to the failure on the part of the APSC to hold interviews in timely manner and also the failure on the part of the departments to move the APSC for regular recruitment. This I have submitted. Lordship would skip the next paragraph, the third paragraph, my lords. The deponent submits that after appointment of the petitioner in the year 1993, in the same year an interview process was undertaken by the APSC for recruitment to the post of assistant geologist, but due to the serious ailment of her mother, the deponent was at Kolkata at that point of time, and as such, the deponent could not participate in the said interview process. Thereafter, another selection process was conducted by the APSC to the same post in about year 2000, but this time it was only for reserve category candidates, and the petitioner, being a general candidate, was not eligible to participate in the selection process. Thereafter, till 2018, no selection process for the post of assistant geologist was conducted by the APSC, and as such, the petitioner did not get any chance to appear in a selection process conducted by the APSC. In the year 2018, a selection process was conducted for the same post, but this time the upper age limit of the petitioner had expired. The petitioner has been serving continuously till date, but could not get appointed on regular basis as she did not get any chance to appear in a regular selection process due to the failure on the part of APSC to hold interviews in timely manner, and also the failure on the part of the respondent department to move the APSC for regular recruitment in time. So none of the respondents have answered to that point which I have raised. That the paragraph 2 of the OM classifies the class of persons. Now, if the class of persons are those persons who have already crossed their upper age limit to sit in the interview conducted by the APSC, then how come sitting in the interview can be a sine qua non? And another submission, my lord, can be quite banal, my lord, but nonetheless, my lord, paragraph 41, the 38 candidates were regularized, and in fact, the other 2 persons in their recital, my lord, in where they were regularized, Lord, you could see the copies which were marked to. None of the copies were marked to the APSC, because APSC had no role to play, my lord, in the regularization. And cabinet decision, my lord, they say cabinet approve. If the cabinet has approved, why did they invoke the OM, my lord? The order says otherwise. There's a cabinet decision which says otherwise. And in any case, my lord, I deserve some parity and equitable treatment from my lord. And it is not the case of the petitioner that I'm not qualified or my services are not required. Now, the director who swears the affidavit, he himself assigns me duty till 2018. Now, in the affidavit, he says I did not attend office from 2016. If someone is not attending office for 2 years in the directorate, people will not assign duties to a person, my lord.
Well, all this submission that has been made by the petitioner hearing, my lord, will have come bearing, my lord, only if the OM has been put to challenge, my lord. All
That is
this
not required, my lord. I'm praying
This is
for
very
reading it down.
specific. Whoever has got the benefit, this particular criteria were followed in shortlisting their name. Now, my lord, giving a, my lord, the special reference to the petitioner.
And
without-
why did the cabinet not consider her case? Because she did not appear in
Yes,
interview.
it is mentioned in that.
But what do you have to say about these pleadings? No interview was held after 93.
So in the pleadings of the petitioner, in the reply, she has stated that there was a selection, but she failed to appear.
No, that was in 93.
That's why, my lord, whatever.
But how can you use 93 select list to
No,
regularize
Once
services?
in their tenure, my lord, from say till 22 years. If
Under
there was
which
any
rule?
selection,
Under which rule?
my lord,
Where is the rule which
no, this
provides?
is a cabinet decision, my lord. It's not a rule, my lord. If the person be a policy decision, one time measure. it
That's
was
correct.
taken.
The cabinet can take a decision. But is the cabinet decision not required to adhere to norms of Article 14?
Article 14 was probably, my lord, it has been followed to my humble submission because, my lord, only the person, my lord, who appeared in the, my lord, APSC, but could not qualify.
Correct, but that
they have
appearance
been-
is,
that's the
that
criteria,
appearance is
that's the
not
criteria. So that has been followed. Because, my lord, just annexing one list of education department without making the education department a party in the petition, at least to support the petitioner. Say, my lord, he is right. In that case also, my lord, the education ought to have been made a party here in, my lord, more particularly to substantiate that particular argument of the petitioner. It is in page 41, that list, my lord, none has appeared in the APSC. Despite that, my lord, they have been regularized under pursuant to this way. Education is not a party here in, my lord.
All right. That's all.
Please place one judgment if your lordship requires. The select list validity for 1 year. If your lordship wants it. Paragraph 7, Supreme Court.
Right, heard Mr. P. Mohanty, learned counsel for the writ petitioner, also heard Mr. B. Gogoi, learned standing counsel, Finance Department, Assam, Mr. S. Shamaria, learned standing counsel, Mines and Minerals Department, Assam, and Mr. B. Gogoi, learned Government Advocate, Assam. D. Bora, learned Government Advocate, Assam, appearing for the official respondents. Arguments concluded, judgment reserved.
Deeply aware, very grateful.
These records are departmental records.
Yes, yes.
So we'll retain it till the judgment. is-
Yes, sir.
Five.
So what has happened in this case?
Yes, I didn't get time to read it, my lord.
Then we will have it after
My-
10 days.
After 10 days.
A copy of the report prepared by the medical board pursuant to examination of the petitioner, namely Master Pragyan Vaishya, has been furnished to Mr. Mahanta only today during the course of hearing of this case. First up. As such, on the request of Mr. Mahanta, this matter is directed to be posted again after 10 days so as to enable him to obtain instruction. Mr. P. N. Goswami, learned additional AG Assam, Mr. D. Nath, learned Senior Government Advocate Assam, and Mr.
Department of.
Mr. R. Chauhan, on behalf of the Asalsa are present. Let this matter be listed again after 2 weeks. Let it come, let him examine.
Otherwise, my lord, this is not a case to resist, my lord. I was supposed
No,
to.
what is the
My lord, he
position?
lost his two, my lord, arms because of electrocution, my lord.
Hmm.
APDCL
No,
has-
that I know. Can something be done?
Yes, my lord. Something can be done. What I propose, my lord, APDCL has already paid 4 lakhs. PHC department will bear all the expenditure of treatment. His education is and his
No,
job.
that's correct, but what is the treatment?
It has to be done in somewhere in Bangalore, my lord. It called my.
Must find it.
No, no, are you aware on the last date he was asked to appear before a medical board?
Yeah, he appeared, my lord.
Yes.
Now medical board has said, my lord, that therefore the board is of opinion that myoelectric prosthesis will benefit him to some extent in his day-to-day activity. There is a treatment for him, my lord. That will bear the cost, my lord. Plus his educational expenditure and a job salary, sorry, my lord, job in the PHC department. My lord.
All right, let him examine. After 2 weeks, we'll come back again. After
There's
2
nothing
weeks.
to resist there, my lord.
No, certainly. This is a very sensitive
True, my lord.
matter.
Obliged.
Examine and see if they can and work out. You can talk and work out. We'll make the provisions by order of the court.
My
That's
lord.
all. Yes, all right.
My lord will be fixing a date, my lord, date.
After 2 weeks,
After 2
partner
weeks.
matter will come.
7 and 8.
Yes.
This is a dispute, my lord, the petitioner seeks, my lord, seniority. And my lord, this petitioner was appointed in the Department of Excise, my lord, subject to my lord, judicial intervention. So my lord, he seeks his seniority from that date of appointment. And my lord, our rule says something differently, but the order of this honorable court which gave him appointment, which effected his appointment, was silent as to whether that appointment was to be counted from initial date or from the date of judgment, my lord. That is his claim, my lord. And I'm considering conditionally that since my lord, much water has flown down and there's a other seniority has crystallized in the form of the for the respondent, let them not be disturbed. Let his case be considered.
What has effectively happened, Your Lordship, is that there was a select list which ought to have been published. That's.
How many writ petitions are there?
There are 2 writ petitions, Your Lordship. The second writ petition is a consequence of the first writ petition, while the first was pending. there were subsequent promotions to the next post.
There are two petitions,
There
three
are two
petitions,
there are two petitions,
two.
two petitions, 5481
So why does it say Jyoti Pran Kumar and two others?
and two others. In fact, one has
Petition ke kon hona, petitioner ke.
petitioners, there are three petitioners, Your Lordship. One in the meanwhile has expired. There are two petitioners now. They have also been promoted. But the fact of the matter remains, Your Lordship, that they need to be accorded their place in the merit list. They have a rule which states that the appointment.
So let's see, give me the other 2018.
Yes.
So why did you file the 2013 writ
The
petition?
2013 writ petition, Your Lordship, was filed challenging the gradation list, which is at page 34
Hmm.
of the writ petition, Your Lordship.
And who are appearing for the private respondents?
The private respondents, in fact, on the earlier occasion, this matter was heard at some detail. On 14/11, this honorable court had gone through the entire matter in detail, but there was no one representing the private respondents. Thereafter, Your Lordship, on 1st of December, the judicial order of this honorable court, which states that unless an affidavit is filed, this court will proceed on the materials available on record. And my submission, Your Lordship, that every record that pertains to adjudication of this matter is before this honorable court. The matter is fairly straightforward. We were given appointment pursuant to judicial interference.
Hmm.
Now we are seeking our interstate seniority as per the merit list. The excise department states that my seniority will be counted from the date of my appointment,
Hmm.
which there is a rule to substantiate their claim.
Hmm.
Our condition and our contention before this honorable court
Hmm.
is that it was only with judicial interference that we were given appointment in the year 1996 onwards. The appointment had taken place in a haphazard manner, Your Lordship, without following any serial or chronological matter in the matter. And we were appointed in the year 1996 pursuant to this observation of this honorable court. And had we approached this honorable court later, we would have been appointed at a later point in time. Now, what they have sought to do, the excise department, is that they have fixed my seniority from the date of my joining the department, whereas my admitted juniors had joined in the department in the year 1993 onwards. These are admitted facts, Your Lordship.
No, we'll consider his case. He
Okay.
may have wrong, he may be have wrong, my lord, but what had happened, my lord, since others have passed him, my lord. The juniors, admitted juniors, he claims to be those juniors, they have already, my lord, promoted and seniority has been, my lord, it's been established till now. So, my lord, disturbing those, that seniority would amount to, my lord.
You
disrupt,
gave
my
him
lord.
consequential seniority.
That is what
that's
I have
all.
been praying for, Your Lordship. In fact, the ground, humble submission, if I may interrupt, Your Lordship.
Hmm.
The item number 7 before the honorable court. Item number 7, Your Lordship, the 2013 matter. If Your Lordship can kindly come to page 40, it is the impugned order which you have challenged. Page 40, Your Lordship. We were directed to prepare a representation before the authorities pursuant to this honorable court's order. Now, this is the order which has been passed by the respondent number 1.
And you got promoted in terms of which order of the court? Page number?
Subsequently, during my Lordship,
Which order of the court you got promoted,
I got appointed.
appointed?
My appointment was pursuant to this honorable court.
Where is that
Appointed
order?
Page 36.
Your Lordship, page 23, page 28, and page 29 respectively, which is at annexure A series, Your Lordship. We had to approach this court to be appointed. The merit list was not published. Page 23, 28, and 29 respectively, Your Lordship. The 3 writ petitions referred.
So you all are appointed on 5th of April 2013.
Yes, we had challenged the gradation list of 5/4/2013 in writ petition number 7, item number 7.
Mr. Sharma, after April, you are not prepared to give the answer. I'm asking something, you are asking
Yes,
something.
yes, sir.
I asked when you are appointed, you are telling me what
Yes,
is
Your
the-
Lordship, I'll explain the appointment. Your Lordship will kindly.
after vacation, a lot of things to do now. If you're not prepared, then
prepared,
you
Your
go
Lordship.
slow.
I apologize.
You are not responding to the
I'm
questions.
sorry, I'm
I
sorry.
just ask you, what is the date of your
I'm
appointment?
sorry, Your
You
Lordship.
give me a sweet answer telling me
I-
what is the gradation list of the,
I can provide the answer.
that can't go on like this.
I'm sorry, Your Lordship. I apologize.
All right, I'll rise now. Let's see. Mr. Nair, what is your matter?
One is with regard to pay parity. And the other one, my lord, the only problem in the other cases, otherwise the matter can be heard and finished up in a very short time. They were directed to get a Caesar list, my lord. It's like this allegation against me is that heroin was recovered from me. 3 small MPUs. Department proceeding, criminal case. In the criminal case, I got acquitted because, my lord, the FSL report that was there and the Caesar that was made could not be connected. Say 0.90 mg was 0.60 mg was seized from me, whereas in the FSL report it's 130, 140, 160, 3 things. So the court held that this is not the same. If that be so, my lord, the penalty that has been imposed in the department proceedings, basing on that FSL report, without, my lord, even exhibiting that, cannot stand. This is the case, my second one. First one would take some time. 9 would take some time. Any day convenient, my lord, if lordship feels, my lord, anyway, if we are rising, my lord will be rising also on any day.
Today there is a
Yeah,
reference.
reference, my lord.
We'll have those all on next Thursday.
Lordship, convenient to your lordship, no
Next
issue.
Thursday.
Thursday.
Next Thursday.
Next Thursday.
This case is next Thursday.